Good evening, everybody, and welcome to the first in this year's series of uh, continuing legal education programs that are offered by the Alternative Dispute Resolution Skills Program at New York Law School. My name is Peter Phillips, and I'm the director of the ADR Skills Program. It's great to see how many familiar faces and names are joining us. It's really wonderful that we get together again. And I'm also really pleased to welcome those of you for whom this is your first time joining us. We're very, very fortunate to be able to welcome Monu Singh, who works at the Office of Collective Bargaining for the City of New York and will help us to learn a bit more how collective bargaining agreements and grievance arbitration in New York City is created and conducted. For those of you who have not taken part in the past, you will notice that everybody, other than the speakers and myself, everybody is muted. That's in order to make sure that the speaker can cover what they are intending to cover. We very much encourage those of you who have observations or questions that you'd like to pose to the speaker to post them in the chat room. The chat field I'm going to monitor all night, and if there's an opportunity towards the end to ask Monu questions, I'm going to take that opportunity. But experience has taught us that it's a lot easier to work that way than to have 87 live mics going and hope that we can still cover the material that we want to cover. Also joining us are Howard Edelman and Rosemary Townley. I'm sure pretty much everybody online knows those two names. Howard and Rosemary very kindly have supported the ADR program and also offered scholarships to New York Law School, and we're very much grateful to them, and thought that at the very least that we could do is to create the Edelman Townley lecture series, of which this is the first. We hope annually to bring questions of labor arbitration and dispute resolution in the labor field to the attention of a broader community. And when Monu has covered the point she wants to, I'm going to invite Howard and Rosemary to join us in making any observations that they might have. So with that as an introduction, may I please introduce Monu Singh, who is the Deputy Chair of the New York City Office of Collective Bargaining. Monu, welcome.
Thank you. Thank you. Hello, everyone. As Peter mentioned, my name is Monu Singh. I am the Deputy Chair of Dispute Resolution at the New York City Office of Collective Bargaining. I want to first thank Peter and New York Law School for extending an invitation to me to be able to come and speak with all of you as part of the Edelman Townley lecture series. I certainly appreciate the opportunity, and I'm hopeful that you will find our time together to, at a minimum, be informative. So what I'd like to do over maybe like the next 45-50 minutes or so is to give you all an introduction to New York City collective bargaining law and the New York City Office of Collective Bargaining. I will be talking a little bit about my role at the agency, my background and how I got here. I'll also be talking about the dispute resolution services that the agency provides to its constituents. And I'll be going over the history and about how the agency was established, how the statute was established, because I think that really give folks a little bit of more context into and a better understanding of why the relationship is the way that it is now between New York City and the municipal unions, and also some insight into how the parties approach dispute resolution. So I know that in speaking with Peter prior to tonight's event, we have a diverse audience, folks coming in from a lot of different backgrounds, and I know that not all of you are familiar with labor law, so I will be going over a couple basic principles. So for those of you who are familiar, just bear with me as we do that, because I want to make sure that folks have at least a fundamental understanding of what I'm talking about. So the first question that I know that some of you may have is like, okay, there's this statute, the New York City collective bargaining law. I work at the Office of Collective Bargaining, but what exactly is collective bargaining? So collective bargaining is a negotiation process between employees who are usually represented by a union and their employer. And that negotiation process results in an agreement or contract that covers things like benefits, compensation, really, working conditions, essentially. And so with that understanding, when we talk about the New York City Office of Collective Bargaining, what we do is we are founded as a neutral agency authorized to administer the New York City collective bargaining law, which is the statute that governs the collective bargaining process in the city of New York, specifically between New York City as an employer and the municipal unions. And these unions, for those of you who may not be familiar, they represent a broad variety of titles, right? So we're talking about sanitation workers, firefighters, clerical staff, janitorial staff, essentially all the unionized employees who work in the many municipal agencies in New York City fall within our jurisdiction. And I would say a rough estimate is we have about 350,000 employees that are covered by our statute. So before I get into specifics about what the agency actually does, I wanted to give you a little bit of context, like I said, about how public sector labor relations in New York City developed into where it is now, because it was a process that actually took several decades. And of course, like with most things, where they started is not exactly where they ended up. But it will give you, I think, a little bit more grounding into why some of the changes occurred over the years. So the agency, the Office of Collective Bargaining, was established in 1967, okay? But prior to that, prior to its establishment, for several decades, New York City had been experiencing employee demonstrations, work stoppages, strikes that were lengthy and contentious and obviously disruptive, right? So in 1957, which is 10 years prior to the establishment of the agency, the mayor at the time, Mayor Wagner, decided, okay, let's try to manage the city employees unionization. And so he set up a process via executive order that allowed for union representation of municipal employees and committed the city to engage in collective bargaining. So that was really like the first official step that was taken by city administration towards collective bargaining for municipal employees. And that executive order became known as the Little Wagner Act, and it established a bargaining unit certification process that was administered by the city's Department of Labor. But although that executive order established a process for employees to be unionized and encouraged collective bargaining, it didn't provide a mechanism at that point for dispute resolution. So really where you were at that point was, okay, these employees can be represented, the city will commit to bargaining with them collectively, but the issue of how disputes that would arise from that process had not been addressed at that point. And so then fast forward a few years, in January of 1965, the city experienced probably one of the longest and most contentious strikes, and one of the most famous strikes in its history, which was the Local 371 Social Service Employees Union strike, and they represented welfare workers. That strike lasted about 30 days, and the union leaders at the time, there were about, I think maybe 9 of them or so, were arrested and jailed for a period of time. And the strike was not resolved until the parties convened and entered a process of tripartite negotiations. And you're going to hear me say that word tripartite several times throughout this this evening's event, because it is really a fundamental cornerstone in terms of how the parties approach dispute resolution in the city. So what that means, what that tripartite negotiation involved was it was a negotiation process between the city, between labor, and neutrals from the American Arbitration Association. And the success of that settlement process encouraged Mayor Wagner to join with the president of District Council 37. And District Council 37 is the largest municipal union in the city. And they represent a wide variety of titles at a number of different agencies. So Mayor Wagner joined with the leader of District Council 37 at the time, Victor Gottbaum, to propose a tripartite panel to study the formulation of a collective bargaining law. And again, that committee or panel was comprised of public representatives who are known as neutrals or impartial members, along with labor and city management representatives. And they all met over the course of several months until they came to an agreement on a bargaining structure. And that agreement was known as the tripartite agreement. So I'm going to share a quote with you that the neutral members actually put out when they were endorsing the tripartite agreement. And they emphasized that one of the greatest merits of the document is that although it is a product of agreement between the city and the representatives of employee organizations, it is to be embodied in a city law. The parties themselves have created a structure for the orderly conduct of their relationship. The agreement represents the exercise of imaginative and unstinting devotion to the common goal of labor peace in the city. And I really love that quote because I think it represents an objective, right? The common goal of labor peace that has been central to the parties' relationship in the ensuing decades. So that agreement was signed by 3 city representatives, including Mayor Lindsay, and representatives of all of the major unions. And then the agreement was turned into legislation, and the New York City collective bargaining law, which I think was disseminated along with a Zoom link today, so you have a copy of that, was passed by the City Council in 1967. And that law, that statute, is the one that OCB administers. So the statute obviously was not perfect at its inception, and it's been amended over the years based on the parties' needs. But the basic structure that it laid out for the office and the 2 boards that are associated with the office. So we have a board of collective bargaining and we have a board of certification. And I'll talk a little bit about those boards a little later. But the board of collective bargaining is comprised of union management and impartial representatives. So the basic structure of those boards and also the office has remained unchanged in 6 decades, roughly 6 decades. So the first 2 decades after the law was enacted, the tripartite process continued and resulted in a series of statutory amendments to the law, as I mentioned. And the board was also busy at that time because the board was establishing a body of case law that governed bargaining unit configuration and the scope of collective bargaining, meaning what the parties were allowed to bargain over. Also, during those first 2 decades, the parties were busy establishing formal grievance arbitration mechanisms and learning how to resolve their disputes via arbitration, mediation, and other OCB processes. So in the hopes, the other thing that they were involved in is in the hopes of sort of facilitating bargaining, making that process easier, and stabilizing labor relations between the city and the unions. The agency and the Board of Certification, which is the board that deals with questions of union representation, were in a process of reducing the total number of bargaining units that existed at that time. So when OCB was founded, it inherited certifications of bargaining units that were issued by the New York City Department of Labor for over 400 bargaining units. So they worked to consolidate those units. They accreted new titles to those existing bargaining units. And over the course of a decade, the total number of bargaining units was reduced to approximately 80. So even for folks who are not necessarily familiar with this process, you can understand just from a logistics perspective bargaining with 400 different groups versus bargaining with 80 groups is a much more easier, efficient process, right? That would result in contracts that could be much more easily executed, and a shorter time frame that was spent in negotiating these contracts as well. And again, like the enactment of the law, much of this unit reduction was accomplished through tripartite negotiation. So you see that sort of approach continues, right? So you can sort of think of those changes, those amendments, the challenges that the parties faced in the first couple decades following the enactment of the statute as growing pains. The city and union leadership was becoming more familiar with the procedures that the law established. They were becoming increasingly adept at utilizing the agency itself, OCB, and the mediation and arbitration services that were provided to resolve their disputes, right? So 67, the statute is passed, the agency is established. The next couple decades are spent trying to kind of organize and bring some structure and institute some processes into the bargaining process and relationship that would encourage an efficient and expeditious way of bargaining and also resolving disputes. So part of the reason I wanted to go over the history of the development of the agency and how municipal labor relations evolved in the city is, like I mentioned at the beginning, like to give you some insight into the relationship between the parties and give you a sense of how the parties approach dispute resolution in this area. So there are certain themes that emerge from this history, and I think that these are themes that are still very much alive today. And one of the most important, I think, is this tripartite approach to resolving disputes. The parties themselves, from the very beginning, have worked together to resolve their disputes and developed solutions to those disputes that meet the specific needs of New York City and its employees, right? So this is not a situation in which a federal monitor came in and instituted some sort of law or imposed some sort of solution on the labor unrest that was happening at the time. What you see from this history is that the parties came together, they worked with neutrals to resolve their disputes, and they incorporated that approach into the statute itself. And you also see that they incorporated that approach into the structure of the agency as well, and the board that issues the decisions. And we'll talk about the structure of the agency in a minute. But the other theme to keep in mind is that for the most part, the parties have remained the same, meaning the city as the employer and the municipal unions. And that's not necessarily uncommon in a public sector unionized environment. Certainly administrations may change, union leadership may change, but what you do see is that the parties have worked together closely for decades. And so there's a long history that they can look to for guidance and support in problem solving. And in fact, some of the representatives on both sides of the table and the neutrals as well, meaning the arbitrators and mediators who help resolve the disputes, are people who have known each other and worked together for decades. And the reason that that is important is that it creates a certain culture and an opportunity to build these long-standing relationships, right? It creates the potential for familiarity and trust to develop between the parties, which for anybody who is in ADR and does mediation work or arbitration work, you know that if there is that trust, that's an integral part of the dispute resolution process. But having said that, I certainly don't want to paint a picture that everything is always lovey-dovey between the parties, right? It's not like every meeting they have, they're holding hands and singing Kumbaya. That is certainly not the case, especially not in New York City. There are definitely issues that are politically or logistically difficult to resolve. Just like any other environment, there are personality clashes between people. There are different agendas and objectives at different times, right? But that goal of maintaining labor peace in the city, right? That the statement that the neutrals made at the outset in terms of when they were referring to the tripartite agreement, is a goal that I think is a shared one, and it certainly has helped in, either pushing or pulling the parties along to help the dispute resolution process so that they can come up with solutions that are mutually beneficial. And I think you also see that approach reflected in the fact that there is, despite what can sometimes be contentious relationship, there is still a high resolution of disputes amongst the parties. There's not a high level of litigation. So in this area of the law, like these parties like to work together. That is their preference. They like to have some control over the solution to whatever it is that they're dealing with rather than litigate it. Obviously, sometimes that's unavoidable, but that is the general preference. So let's turn to the structure of the agency. As I mentioned earlier, we have two boards, the Board of Collective Bargaining and the Board of Certification. The Board of Collective Bargaining is comprised of two management or city members that are appointed by the mayor. We have two labor or union members appointed by the Municipal Labor Committee. The Municipal Labor Committee is an association of municipal labor organizations, and three neutral or impartial members, one of whom serves as both the director of the agency and the chair of the board. The two other impartial members are unanimously elected by the city and the MLC. So under the statute, the Board of Collective Bargaining, or BCB, determines questions concerning improper practices, arbitrability of grievances, the scope of bargaining. They deal with impasses and appeals from impasse panel awards. And, they handle primarily like violations of the statute or impasse, questions about impasse. The Board of Certification, on the other hand, is comprised only of the impartial members, and they resolve questions concerning union representation of public employees for purposes of collective bargaining. And what that means is if there is a particular title in the city that's not represented, so for example, we'll say secretaries are not represented. They are, but let's say they weren't, and a union wanted to represent them. The question of whether or not they could be represented by a union would be one that the Board of Certification would decide. Then those are the two boards. And then the agency has, internally in terms of full-time staff, the agency has two divisions. So we have a legal division with a general counsel, deputy general counsels, and a number of trial examiners who essentially function as administrative law judges. They hear improper practice claims or claim violations of the statute, and they draft decisions that go to the Board of Collective Bargaining for review. And then the other division in the office is the division that I oversee, which is the dispute resolution side. Okay, so what are the services provided by dispute resolution? So from the very beginning of the agency's establishment, you had arbitration, impasse proceedings, and mediation. Those were the three main methods that the parties used to resolve their disputes.
Manu, before you get into this section, I think
Sure.
it would be timely for me to intervene with the first CLE code. Those of you who are veterans know that we're obligated to fill in this form that was sent to you with three codes to demonstrate that you were present during the entire program. The link for that is in the email. So right now, if you will just write this word down, and in 20 minutes, I'll give you a second word, and at the end, I'll give you a third word, okay? And the first word is city. C-I-T-Y is the first code word for filling in the CLE form. That said, Monu, excuse me for interrupting you. Go on ahead.
Oh, anytime. I know those words are critical for people who are trying to get CLE credit, so feel free to interrupt. Okay, so we'll start with arbitration. Since the inception of the statute, it expressly provided that the policy of the city is for collective bargaining agreements. So again, those contracts between the unions and the city to contain grievance procedures that culminate in impartial binding arbitration. So for those of you who are not familiar with grievance arbitration, it's a process by which the parties can resolve disputes between there are disputes between employers and employees when there is a disagreement about the interpretation or application of a particular term or provision of a collective bargaining agreement. And most of the collective bargaining agreements in the city, they have very specific provisions. So like they have a list of things that can be pursued through the grievance procedure. And it also includes disciplinary acts, it includes violations of an agency's policies, etc. So that tenet of having that grievance procedure in the collective bargaining agreements has been almost uniformly adopted by the city and the municipal unions. And what it does is it ensures that, unionized employees have access to final binding resolution of their grievances. And most of the negotiated grievance arbitration provisions provide for impartial binding arbitration and require that requests for arbitration be filed with the Office of Collective Bargaining. Additionally, most of them have a 4-step grievance process that's laid out in their CBAs. So the first step of that process typically begins with a grievance form being filed, usually by the union, alleging a violation of a contract provision. A response is issued by the employing agency. And so let's say that the response is that the grievance is denied. So there's an opportunity to appeal at the second step. And that second step is usually appealed to the agency's internal labor relations department. So a labor relations representative will review the case and issue a response. If it's again denied, then the grievance can be appealed in the third step to the Mayor's Office of Labor Relations. The Mayor's Office of Labor Relations is its own separate agency, and it represents the mayor's interests at the city's interests at the bargaining table. And so the grievance will go there for review and for hearing. And if it's denied there, then it goes to the fourth and final step, which is binding arbitration. And that is appealed to my office, to the Office of Collective Bargaining. In order for a case to be arbitrated, the parties not only have to file a request for arbitration, but they also have to file a waiver. And the waiver that needs to be filed is a waiver of both the employee and the union's right to submit the underlying dispute to any other administrative or judicial tribunal, except for purposes of enforcing the arbitrator's award. So what does that mean? That just means that you're ensuring that the issue is not relitigated in another forum. If that waiver is not submitted, I do not process the case. That case is going to sit there until we get the waiver. So the cases that are filed for final adjudication through arbitration are typically heard by an arbitrator from what's called a register of neutrals. So in addition to the tripartite process, this register of neutrals is another way in which OCB is kind of unique because parties are not required to go to AAA, to the American Arbitration Association, or to any other organization in order to find an arbitrator to hear their case. We have our own list of arbitrators and mediators, and we administer that list ourselves. So that list of arbitrators have been approved for inclusion by a majority of the board members. So in order to appoint an arbitrator to a case, I send both sides a panel of 9 arbitrators. They rank their top 5 choices, they return their selections to me, and after which I appoint the arbitrator. So arbitrators under our rules are vested with pretty broad latitude in how they conduct the hearings. They can issue subpoenas, they can administer oaths, they appoint the time and place of the hearing, they can adjourn or postpone the hearing. They can help the parties if the parties agree to it. They can help the parties resolve the dispute without going to award, so they can also help mediate the case. And then if the case does go to a hearing, at the conclusion of the hearing, the arbitrator renders an award or decision that is final and binding and can only be appealed through the New York State judicial system. So we are fortunate here in New York that OCB's register of neutrals has, since its inception, attracted the most experienced and well-respected neutrals in the field. And I'm not just saying that because Howard and Rosemary are also on this call, but it is actually true. Since its establishment, it's drawn arbitrators and mediators with really diverse backgrounds and experience. So we have had clergy members, we have had academics, retired judges, college presidents, management and union representatives with a lot of experience, and attorneys serve as neutrals on our panel. And again, since its establishment, there has been a process for inclusion on that register that remains in place today. And it is a somewhat rigorous process to be included on that register. So in order to be appointed, applicants have to have extensive experience in labor matters as a neutral, and they also need to be recommended by both sides. They need to be recommended by labor representatives, management representatives, and also other neutrals. And then a majority of the board, including at least one city and one labor member, needs to approve the applicant before they can be appointed to the register. So what do you see here, right? You see, again, that sort of tripartite approach to the whole process. It kind of informs everything that we do, that we want, the parties agreed that they wanted to have a voice in every aspect of dispute resolution. So you will continue to see that repeated. So our register also represents the other theme I discussed, which is this long relationship and tenure of professionals in the field. We have a lot of register members who have served on the panel for decades. And what that long service has done is it's contributed greatly to the stability of New York City municipal labor relations overall, because they have a deep understanding of how the city functions. They have a deep understanding of what is important to the unions. They understand what both sides, what some of the roadblocks or issues that might exist for both sides in resolving an issue. And they also have an understanding of the relationship and history between the city and the municipal unions. We have currently 3 former general counsels on our register, 2 of whom served as general counsels of New York City Office of Labor Relations, and one of whom is formerly a general counsel at District Council 37. And they've spent several years of their career in municipal labor relations. So you can see that sort of perspective that they bring to these cases, which ensures that you're not going to get decisions from these neutrals that are going to upset the apple cart, right? You're not going to get something out of left field that's going to overturn the way things have been done in the city for years. So what I just talked about is what I'll refer to as the standard arbitration process that exists in almost all of the collective bargaining agreements. There are some exceptions. But there's also another arbitration process that I administer for the agency, and that's called the expedited arbitration process. So over the years, the agency has really consistently, I would say, embraced ways to improve the dispute resolution process. And one of the most effective methods has been the establishment of an expedited arbitration process. And it was first established in 1980, primarily because there was a backlog of cases. And these cases, many of them, the parties found were cases involving like a warning letter, 3 hours of overtime, a dispute over a day's pay. So they weren't necessarily big, complicated, controversial cases, but it was taking months for them to get heard because there were just so many cases, and there was only so many that could be scheduled at any given time. So people were waiting months for a resolution to what were relatively simple issues. So the parties decided to set up this expedited process. And again, it was developed through negotiations between the city and District Council 37. It underwent a number of modifications over the years until the parties agreed on a process that has been in place since 1992. So because of the types of cases that are processed through the expedited arbitration process, they move quickly. Multiple cases can be heard in a day. And while a full opportunity is given, of course, to the parties to make all of their relevant arguments, testimony is often taken in a narrative form, which means, there's no direct examination, cross-examination, redirect. A witness can just get on the stand and say, I was issued this warning letter and I don't think it's fair, and this is why I don't think it's fair, and that can be sufficient. And decisions that are issued are shorter, they're non-precedent setting, and bench decisions are permitted as well. And since 1992, the agency has processed, thousands of cases through this expedited arbitration procedure. Many of the cases are settled right before the hearing or actually at the hearing with the arbitrator's assistance. So it's proven to be a very successful method of moving through these types of cases with smaller liability and simpler issues. And currently, I hear these cases, all the cases are heard by me and one other arbitrator. I set the calendar for the year, I schedule the cases, and then, of course, work with the parties to resolve the cases if needed. So that is the way that grievance arbitration has been handled procedurally under the statute and under our rules. We also offer a process to resolve impasses that may arise between the parties. So again, for those of you who are unfamiliar with labor law and labor negotiations, sometimes the parties may be in the midst of contract negotiations and reach a point where they simply can't come to an agreement, right? So they reach a point of impasse in the negotiation process. And if they feel that they can't find a way through that, they can access the impasse procedures as a way to resolve the impasse, which means that they would go to binding arbitration. And again, I'll deviate for a second, just to have a little bit of a history lesson here. So early impasse procedures in the NYCCBL were non-binding, and they were not universally accepted. So some people believe that those procedures, along with the unions at that time had given up the right to strike, it would undermine or eliminate the labor movement. Another criticism was that the use of impasse procedures to resolve contractual disputes would undermine the parties' ability to negotiate and would ultimately replace negotiated settlements. So people were afraid that people would just go to arbitration and have a third party impose an agreement on them. But these fears ended up being misplaced. And from what we saw is from 1968 to 1972, the number of requests for impasse consistently declined. And then in 1972, an amendment to the statute became effective, making these awards binding, which had the effect of, again, kind of stabilizing the process to ensure that the parties weren't in this constant cycle of negotiation, of going to arbitration, rejecting the decision, and then going back into negotiation. So those awards became binding. And then the following 2 decades really demonstrated the parties' continued desire to settle disputes without resorting to impasse. From 1972 to 1992, so for the following 20 years, the city and municipal unions invoked the impasse provisions in less than 8% of all the bargaining units. And since then, the parties have shown even higher rates of mutual resolution of their contracts, and they've used the impasse procedures even less frequently. But that being said, when they are utilized, the impasse procedures tend to be highly effective. So their success in part may be largely due to the flexibility of the rules, right? So in keeping, again, with the tripartite nature of the statute and the deference given to the parties' interests, the parties may request the appointment of an impasse panel jointly or individually, or a panel may be appointed by the Board of Collective Bargaining. The panel can be comprised of 1 arbitrator or 3 arbitrators, and they have the power to mediate, they hold hearings, they can compel the attendance of witnesses, they review data, they, can compel the production of documents, you know, essentially take whatever steps considered necessary to resolve the impasse. And like I mentioned, the rules that govern the impasse procedure again reflect that tripartite perspective, right? Once one or both of the parties file a request for impasse, I review the request and then I conduct what's called an investigation, which means that essentially that I consult with the parties to get more information about the status of negotiation. So I will call them up. I will say, what's going on? You know, what is the issue? How far have you gotten? How many sessions have you had? Have you exchanged proposals? You know, I'm doing an investigation. I'm investigating what has actually taken place at the bargaining table. If the parties think that mediation might be helpful, they can request that I serve as the mediator. They can request that somebody else from our register serve as the mediator to assist them. But if it becomes clear that the parties are indeed at impasse, then I prepare a report that I present to the Board of Collective Bargaining, because ultimately the board is the one that's going to decide if the parties can go to impasse arbitration, right? So again, remember that the board is comprised of labor management and partial members. So the majority needs to approve the request for impasse arbitration. If the board feels that more negotiation is required, if the board says, you know, the parties have only met a couple times, you know, this isn't sufficient, they can send them back and deny the request for impasse and say, go continue negotiations and continue working on this issue. But let's say the board does approve the request. So then I will go back to the parties to see whether they'd like to have the case go to a single arbitrator or before a panel. And then it'll go to hearing. And then once the case is at arbitration, as I mentioned, the arbitrator has, or the panel has the ability to help mediate a resolution or conduct a hearing. And then they issue what's called a report and recommendation. As I mentioned, that report and recommendation is binding, but it can be appealed. And that appeal process would be that it goes to the board. There was some apprehension initially that this might prove to be sort of two bites at the apple, but it hasn't been, because the members of the board have been unwilling to substitute their judgment for that of an impasse panel. And so when they review these impasse recommendations, if they're going to overturn it in any way or in part or in whole, what they're really looking for is clear evidence that the proceedings have been, you know, tainted by fraud or bias, that there's been a mistake in terms of application of law, that evidence hasn't been considered, or that the result is sort of patently inconsistent with the evidence that has been submitted. So it's a pretty high standard that has to be met in order for the board to overturn a decision by an impasse panel, which again contributes to those stable labor relations that you've heard me refer to in the city. So that's the process for the impasse procedure. So that brings us finally to mediation, which is the third form of dispute resolution that the agency offers. So at its inception, the statute incorporated mediation into the formal dispute resolution process, which kind of highlighted its status as an integral part of conflict resolution. Under the statute, OCB is responsible for the process of appointing mediators. It grants the director pretty broad authority to invoke mediation in order to resolve collective bargaining disputes. So that means that upon the request of a party or both parties, or by the director's own initiative, if the director determines that collective bargaining negotiations would be assisted by mediation, they can appoint a mediation panel to help the parties in arriving to an agreement. And so on a day-to-day basis, part of my responsibilities is to assist the parties in mediation or assign a mediator or mediation panel to a case. And pursuant to the statute, the parties themselves have actually a statutory duty to cooperate with the mediation panel in an effort to arrive at an agreement. So there is a responsibility that is built into the statute on the parties themselves to be active participants in that process. And so just like the other dispute resolution processes that I mentioned, Mediation has been used from the very beginning by the parties. The year after the agency was founded in 1968, there were 35 cases that were filed by the parties seeking mediation. And those cases actually ended up having far-reaching implications. And in fact, it was around that time that the parties negotiated what's called the first citywide agreement. And the citywide agreement is a collective bargaining agreement that covers general working conditions and non-economic matters for city employees. So we're talking about personnel and pay practices, holidays, annual leave, overtime, things like that. And that was particularly significant because it was the first time that the city had entered into a single collective bargaining agreement on issues that kind of cut across all department and agency lines. I mean, these were issues that applied to all the employees. And so that was arrived at through the mediation process that had been built into the statute. But it's not just for collective bargaining that mediation is not just available for collective bargaining issues that come up. It's also available on an ad hoc basis for requests for arbitration, representation cases, improper practices. I will regularly get requests from the parties on a particular arbitration case if they think that it would be helpful to have somebody just sort of step in and talk to their clients a little bit from a neutral perspective to kind of help them resolve the issue. So that is also available to them. And so for those of you who are involved in mediation work, you know that one of the great things about it is that unlike arbitration, successful mediations result in outcomes that the parties can control, right? And it gives them a voice and power over the final resolution, which is, I think, particularly to parties in our jurisdiction, is a very attractive approach. So those are the dispute resolution processes that the agency provides. And I see Peter back on the screen, so I think he has another word for us.
I do in just a sec, but there, I think, is a very interesting question that was raised by a member of the audience here. And let me just read it to you. Wouldn't it be better to require term limits for the neutrals serving on OCB's list? Otherwise, there is evidence in bureaucratic studies that over time people can become captured by other interests, so they are no longer neutral. So let me ask you, Manu, has there been a concern expressed by either of the parties with respect to the neutrality of the arbitrators over time, and a desire of any party to refresh the list?
Yeah, so I think that's actually a great question and speaks to a real concern and real issue that can come up. But I think that what I have seen happen with our list, because of the way that the process works, right, which is that I send out a list of 9 arbitrators and the parties rank 5, that there is not only a constant sort of selection process that's taking place, you're not just getting the same 10 names over and over again, but also the parties have a way of regulating the process, meaning if there are arbitrators that they feel are not providing the level of service, I would say, that they have come to expect for one reason or another, they can communicate that to us. And because of the nature of the relationship that they have with each other, that is a discussion that they can have. So certainly there have been situations over the years in which if the parties feel an arbitrator is not providing whatever you want to call it, the level of care that the parties have come to expect, then that name may no longer be in rotation.
I see.
I respond.
So it
Absolutely.
happens in response to either one or both parties in the usual course of business, if I'm hearing you right. Right. And for that reason, I guess it's your view that it's self-correcting. In other words, that you don't need to put term limits in?
Yeah, I would say that that's accurate. And sort of to address the I guess the second part of the question, or the third part of the question, which has to do with refreshing the list. I mean, we're in a constant ongoing process of accepting applications and trying to get new people to come on the list as well, and encouraging the parties to try out arbitrators that they haven't tried, because the reality is, you want to have a deep bench that you're pulling from, right? You want to have folks that you trust, as many folks that you trust on the panel that you're using to hear these cases. But I also see that Howard has some comments that he'd like to make.
Yeah, I do. I mean, I think, first of all, I don't have to be as circumspect as Monu, but in any event, I think it's a good question, but not a great question. And the reason is this. Like any, quote, business, industry, profession, the word gets out on the street. And when an arbitrator begins to get the reputation that is implied by the question, the street, meaning the advocates, tend to self-correct. And unfortunately, what happens, and I'll, for some, and make no mistake, they're a real minority, but unfortunately what happens is that for minority arbitrators, they get the sense of what's going on, so they swing the other way, and then everybody hates them and they don't get other work. So I think the process, as correct as it exists, and as Manu explained in terms of refreshing the list and like, it works very, very well.
I want to turn both to Howard and Rosemary in just a sec, but as Manu suggested, I owe you a second word, okay? And your second word is new, N-E-W, new. I don't know. I mean, if what we wanted to do was to start from the very top of the list of people who would join us and offer the practitioners, the neutral's perception of this, I think these two people would be number 1 and 2. We're ridiculously fortunate that Rosemary and Howard are going to be able to join us now. And Rosemary, I don't know if the two of you have talked, but you want to start off, and what I'm looking for is just, based on the background and the explanation that Manu has shared with us and your experience in the field. Does this work or doesn't it? You know what I mean? How does it?
Well, I have nearly 40 years experience at this point, and I find that what has been described so far works perfectly. It is self-executing. The word gets out so fast, and I don't know if there's any other profession where you could ruin yourself so quickly. And when I remember when I was in about 10, 15 years, receiving a call from a member on the panel saying, how many cases do I have to throw to union? How many to management? So I'm sure I'm reappointed. So some still have that view, which is really scary. But I know we're going to be short on time. And I want Howard to be able to cover his experience in New York City. All I can say is 2 of my favorite cases under the OCB board. One involved a coroner with his assistant, and the assistant had asthma, and he filed an out-of-title grievance because the skull dust that he had to shave off the skull when they did an autopsy was getting in his nostrils, and he brought the skull dust to the hearing and slapped it down for emphasis.
Do we have a cool profession or not?
Yeah, we're gonna see right in And the second had to do with the and I grew up in Buffalo, that's the accent, but farriers, F-E-R-R-I-E-Rs, the gentleman who shoot the horses for the mounted police staff. And I was just fascinated by how much these gentlemen love the horses and how they explain the process. And I think right now, you can bring a horse in, I can shoe it. I can shoe it without question. And they all
were you mediating or arbitrating?
I was arbitrating. It's another out of title because of the employees felt that they were classified too low because most of their work really involved using iron and doing a lot of different types of things that were not at all included in their description. And I agreed with them, but boy, I can't believe I feel so good. I can actually shoe a horse. Anyway, I'll turn it over to Howard.
Okay, so I'm not as funny as Rosemary. I'm sorry. But I do want to make just one minor procedural point, which is a number of you may have a lot of questions. It may extend our time. Please feel free to email me at H for Howard, C for Charles. You can blame my mother and E. Edelman, HCEARB@gmail.com. I promise you, I don't know when I'll get to them, but I promise you I will answer them all. No matter how dumb, I will answer them. I don't expect they will be, but seriously, please, please do that. I want to focus on one element that I think is important. Manu gave, it was all terrific and all that stuff, and it really was. She mentioned impasse and interest arbitration, which is, most of you know, and she explained that's when the parties cannot agree on terms for a new contract, and they engage in neutral, and it's a 3-member panel, and most of the time, you should know, not necessarily all, but most of the time, the 3-member panel is composed of somebody selected by the union, somebody selected by the employer, and the third, the so-called neutral, although technically each has an equal vote. I could talk for hours about that. But what I want to really focus on is that the impasse proceeding, by virtue of it being part of the New York City process and a part of a process within the public sector generally, is really interesting and unusual. The tendency is that everybody, you present the evidence to the arbitrator or to the 3-member panel, and the 3-member panel decides, and that's it. And somebody dissents, and somebody concurs, and everybody goes on the merry way. That's really not totally what occurs in most situations. In most situations, what really happens is that the real work of the panel takes place in the executive sessions after the evidence has been presented by both sides. And that's an important distinction, because what is the neutral? We'll assume for the sake of discussion is 1 neutral and 2 neutral advocates. But either way, what takes place in that session is extensive discussion, not only of the evidence, but of how, and I'm going to use the word that, a term that Monique used, how do we maintain labor stability within this particular bargaining? So that the result, while it has to be evidence-based, is more a process of additional negotiation than it is a totally hard look at the evidence without considering any other factors. Let me give you a general example, and later on I'll give you a specific one. General example is, so the 3-member panel is sitting around, and the union says we've got to have 4%, and the employee says we can offer only 3%, and you go back and forth, and the union tells me why the 4% is worthy or warranted in terms of the other settlements, and the employer says, yeah, but the economy sucks, so it really should be 3%. When I say, and of course this is oversimplistic, but when I say, hey guys, why don't we agree on 3.5? What I'm doing is I'm not saying one is right and one is wrong. I'm saying that the labor stability or labor relations stability is best served by, in this case, not all by any means, splitting the baby. And nobody can tell me with a straight face that I can't find a rationale in a case like that for 3.5 as opposed to 4 or 3. All I'm saying then is it's a very dynamic process that, while, look, I have to write something that I can justify, of course, but that is more than just evidence-based. In fact, just as an aside, there was a case up, this was not related to OCB, but related to PERB, but the same process. And there was a case decided outside of a suburb of Buffalo many, many years ago. And it was a either county or subdivision government, and both the employer and the union representatives, who were members of the panel, agreed to a very large increase. Now, you could debate the reasons, you could argue, why the employer was giving the union so much money. It has all sorts of political things. Remember, only in the public sector do you elect your own boss, essentially. So you could go on forever about that. But they agreed to a really large increase. And the arbitrator, to his credit, there was a man, said, I'm not signing this, I'm not signing off on this. This is outrageous. I can't justify any of this, and I'm not doing it. And they said, too blankety blank bad. And as a result, the award came out, the employer and union members of the panel voted for it, The arbitrator voted against it. Very rare, but it occurred. And ultimately, the court said, you could agree or disagree, the court said, hey, 3-member panel, everybody has an equal voice. We uphold the award, even though, you know, it may do something of an injustice to the process. So I want to emphasize that interest arbitration, the impasse proceeding, is a fascinating process that really just goes beyond what in fact is presented to the arbitrator. I have one other comment, and I got to look at my notes for that. The interest arbitration process, as you can infer from what I'm saying, is really in part a jawboning process. It allows the arbitrator, I'll say the arbitrator, all three are arbitrators. It allows the neutral or the chair to go to the advocates on both sides and say, look, I can't support this. Why don't you tell me something that I can support, which will be of some value to your side, but I can't support this. And I want you to know that if you don't come up with something that makes sense, you're really running the risk of an adverse result. So it's more than just laying back and presenting an alternative. It involves a strong. I'll use a kind of tough term, a strong arming element, and I know that'll cause some hackles, but I think it's right. Now you gotta think of something. You gotta think of the counter position, and that was implied in one of the questions that was asked that we discussed before. What happens when you have a small union in a big New York City? How can you strong arm New York City to do something that that it doesn't want to do? And does this have an impact on further further work, if you will, as an arbitrator? Well, look, I'm old enough and gray enough and whatever enough, not to give a damn. But more important than that, more important is that over time, arbitrators' reputations become known. And I implied this before. And I've had cases where an advocate has called me and said, yeah, that took courage, whatever it was, but I'm glad you did it because I think it was the right thing, whether it favored management or union, whether it favored, and by the way, there are also large unions and small employers, although not necessarily within New York City.
I mean, if you Google Howard's name, you will see some of those tough cases that he's referring to. And if I may just make one point, there is a parallel agency to Monu's. She's referring to New York City. New York State is the New York State Public Employment Relations Board, PERB. It's a 3-member board. I'm the neutral member of that board, and it handles essentially the same types of issues that Monu talked about with respect to New York City. We just sort of run on parallel tracks, except when we don't, and that happens very, very rarely. But there are these two separate agencies, and sometimes you can do both. And I don't know as much about that as Monu would know in terms of filing. I just want to throw that out there so you don't confuse the two entities.
Howard, is there something about, I'm asking about settlement rates or instances of resolution of filed arbitrations that terminate for reasons other than an award, okay? Does that happen frequently? Is there something about the process that bakes in an incentive for the parties to figure it out before the arbitrator actually rules?
Okay, I think that is not a good question. That's a great question, and it's not just because Peter raised it, but it really is, and I think it requires something of an in-depth answer. As follows. Yes, I always, and this is my practice, it's not every arbitrator I know, and I respect them as well. I always universally ask either at the beginning of the hearing or usually after the opening statements, is this matter resolved? I always do. And I know some arbitrators feel it's intrusive by the arbitrator. He shouldn't or she shouldn't get to know, enough about the case. before the actual evidence is presented, et cetera, and so forth. I'm not bothered by that. I can wear the mediator hat. I can wear the arbitrator hat as well. But I always ask, and of course the parties are free to say no. And I guarantee you, the arbitrators who use this protocol, if you will, don't take any umbrage if the parties say no. We tried, we can't, or we didn't try, and we don't want to try. You decide.
But
Yeah,
could
well,
be a different point though. I'm sorry, Peter.
I was just thinking about Major League Baseball, okay, where
Sure.
the nature of last offer arbitration not only makes the last offers more reasonable than they would
Yes.
otherwise be, it also is a disincentive to going through the arbitration. You know what I mean? It tends to, my understanding anyway, is that it tends to reduce the number of actual awards because what happens is that the people want to avoid that kind of an outcome. Does that happen
Totally
in New York
accurate. I
City?
do baseball cases. I love them. I mean, I just love it because I like the sport. You're totally accurate. And generally speaking, I would say less than 20% of cases that are filed actually go to an award in baseball. And it does exactly what you say. Be aware, though, that in baseball, a settlement or an award has very significant effect on the rest of the universe. That is, on the rest of the players who are up for arbitration. If Smith got X, then I should get Y is basically the argument. Comparatives is key. In a lot of cases, not all by any means, but a lot of other kinds of arbitrations, a settlement is not. Now, one last point I want, certainly let Rosemary. But last point is, at times, the parties will say to me, Howard, here's our settlement, A, B, C. And impliedly, we're both gutless. So you have to write it. Now, some people take umbrage at that. I do not, so long as I'm convinced that it's fair. I have rejected that offer, if you will, occasionally. But usually with sophisticated advocates, they're not imposing or they're not agreeing to anything that's, way off the charts. But I think that is a legitimate role of the arbitrator, because it's my view, the arbitrator is there to solve labor relations problems and not simply to stand with a sort of a presumption of king-like, qualities. Rosemary, I'm sorry.
Monu, among your responsibilities is the maintenance of the list of neutrals, right?
Yes.
Our ADR program here at the school every year has been addressing the question of increasing the diversity of practitioners, mediators and arbitrators and, professionals. And the problem that we always deal with is that most client representatives, before they agree on a neutral, are going to ask around and say, who's worked with this neutral before? And more than other areas of the law, people tend to get rehired rather than, and it creates a problem for younger people or newer people. And there's a disproportionate number of people who are older and people who are male and people who are white in our business. Now, I'm broadly, this is a broad brush, but that tends to be the phenomenon that we try to deal with. I've never found a key to the door. Every single time we have our annual diversity symposium, nobody comes up with, the magic wand to fix it. But in your position, how do you approach the challenge of making sure that your panel is younger or includes people of color or includes people who are women or includes people who may not have a super long list of prior experience?
So you're asking me if I have the key. I can tell you that I also don't have a very clear answer to that. But I can tell you that this is something that certainly is a topic of discussion amongst, I think, not just I think probably industry-wide, and when I say industry, I'm talking about ADR in general, is how do we make the neutrals be a little bit more reflective of the parties that are actually appearing before them as well. So from OCB's perspective, we're actually actively involved in this process right now. I mean, we're fortunate in that our panel has pretty consistently, I wouldn't necessarily from the very beginning, but for the past 20 years or so, we have about 25% of our panel has been women. And we are always, whenever we get new applicants to be on the register, it is something that we highlight to the parties, that, you know, if they are from a more diverse background, you know, you can usually see it in the work that they've done as well at times. So it's something that the parties pay attention to. It's something that we make sure that we want to point out and support, because I think that the concern that you expressed is a very real one, and it's very alive right now in ADR in general.
Well,
So
could you, I'm sorry, but could you articulate, just because there are so many people who are here who have a concern about perhaps being able to serve professionally, what are the attributes that that your office looks for in people who would make a good addition to the panel of arbitrators and mediators?
yeah, so I think, you know, I touched on some of them earlier, which is that it's, and to be clear, I am not putting these folks on the panel. It's the parties who are deciding to have them join the register. So what they tend to look for is experience in labor relations, right? So part of the application is we request that there are decisions that are enclosed, that folks have to indicate, you know, their work product, what they've done. They also look for kind of ideally like some city experience that they've worked with either side, either labor or management. And they look for recommendations from neutrals that they know. So it's sort of like, if you have a community of people who are all recommending you to be on this panel, that's what the parties are looking for, because particularly those references, our parties will follow up on them and call around, just like Howard was saying, right? Like, what is the word on the street in terms of your reputation? Are you somebody that is easy to work with? Are you somebody that's clear? Are you somebody that's decisive? Are you somebody who pays attention to details? I mean, these are all qualities that the parties are looking for in a neutral, and just in general. And that's kind of what they want to know. Can we trust? I think essentially what the question that they're asking, right, underneath it all is, can we trust this person with the issues that we're dealing with in order to be able to facilitate a resolution or issue a decision either way? So
Rosemary, do you have anything to add to that in terms of your experience?
Well, I was just going to add that the American Arbitration Association has represented for the last maybe at least 5 years that every list that goes out in a labor case is comprised of 30% minority. I mean, they were involved in DEI many, many years ago. Now, whether those individuals are selected to hear the case, I'm not sure. I don't know if those statistics are out, but I find that to be the major issue. I've been on many DEI committees and so forth, where you could do training and find people who are excellent, but you can't force a party to accept that individual. And it's changed over the last 20, 30 years. I mean, years ago, you know, you'd be selected to, you know, hear a termination case. Nowadays, they won't even pick someone to hear, let's say, a letter in the file, which is quite down the road from in a disciplinary program.
Yeah, but DEI aside for a minute, when someone comes up to you and says, I'm ambitious in this field, do you have any advice on how I can advance myself, you know, by getting on panels such as the OCB panel? What advice do you give them?
Well, generally speaking, talking about applying to either PERB or OCB or the American Arbitration Association, you know, they'll have to do it directly to the individual responsible for reviewing the awards and that. But I also will tell folks, be very active in organizations where you will meet advocates, whether it's a bar association, whether it's LIRA, but it must, unless they can kind of match a face with the name, it's not going to be very easy for them to select. Even if they call their, a colleague and say, what do you think of John? They're still very reluctant. I don't know if it's the economy that somehow has put a damper on the notion of new people, but because I've served as mentor to many new arbitrators, and they still have that problem of acceptability.
Yeah.
I would echo everything Rosemary and Monu said on this topic, but I would simply add, in terms of qualities of an arbitrator rather than experience, which is critical, of course, but and I've written this actually. I've distilled it to three phrases. The first being integrity, and that's first. The second being a good labor relations sense. And that may sound amorphous, but somebody who really understands what goes on, and I'll use the private sector phrase, on the shop floor or in the office or in the schoolroom. And the third, and properly so, is intelligence, because you don't have to be too smart to do this damn thing, because everybody teaches you. They tell you what the arguments are, and you have to make the judgment based primarily on the other two.
Our third number, our third word here is York, Y-O-R-K, York. Monu, thank you. Rosemary and Howard, thank you on all kinds of levels. You guys are just terrific to our school. You're terrific tonight. And the three of you, I just couldn't be more grateful. For everyone who joined, thanks for coming by. I hope everybody gets what they came to get. And thank you all. We'll make sure that you get notice of next month's.
Thank you all for attending.
Thank you.
Thank you. Yes, thank you for the
Thanks,
invitation.
Manu. It was great.
I will.
Thank you.